welcome back to another episode of How To with Tara Rule. This is the second part in my series of how to be your own attorney. And today we are going to learn how to write up our complaint. For the sake of this video, I'm going to just assume that you've already watched part one, which kind of gave you a run through of what to expect, terminology you need to know. So if anything in this video confuses you, go back and see part one. Please consider becoming a patron on my Patreon. The link is down below. This will help me to be able to continue to make these educational videos for you guys. Also linked down below, you can find a fill in the blank Google Doc with everything we go over today. So you can kind of use a formatted complaint that you can fill in the relevant information specific to your case. Be sure to hit that like button, subscribe, and turn on notifications so you know when the next video comes out. And okay, now let's get started. We're going to start with our heading. Now, one thing I want to say is that complaints are numbered and so are the pages, but you don't want to add page numbers or numbers to any of your paragraphs or lines until you're about to print it out, because there's a high chance you're going to go back and move things around. Let's start with the heading. The heading is going to first line, United States District Court. Right under it is going to be whatever district court you're filing in. Let's say for a made-up scenario, my case takes place in Southern California. So the next line will be Southern District of California. The next line is going to be your name as the plaintiff. So you're going to put your name right under it, plaintiff, versus the defendant's names. So let's say in this case, we have two defendants, Lady Ladyson, MD, and Hollywood OBGYN. Lady Ladyson, MD, comma, Hollywood OBGYN, right under that defendants. Your heading is complete. Again, for this made up scenario, everything is like hypothetical. None of these people exist. And if any of these business names or anything exist, it's totally coincidental. It's not a real case. Right under that, you're gonna add a place for the case number. You're not gonna have your case number until you file, so you'll just leave a little space next to it blank, because you can always go in and write it after you've actually filed the complaint. Most district courts, and please check in with your local rules, and you can do that by calling the court clerk and double checking and verifying that this is the case in your district, but most district courts will allow you to demand a jury trial or not. In most cases, especially if you're dealing with a corporation, I would recommend that you demand a jury trial. And the reason for that is otherwise you're going to have to go through arbitration. And the arbitrator oftentimes works for the corporation that you're going after. So you're not going to get a fair, unbiased approach. Especially if your case is more open and shut, cut and dry in your favor, a jury of your peers is much more likely to give you a fair result. And as such, the defense attorneys are going to be way more likely to settle before it goes to trial, because they know that they're not going to be able to really manipulate a jury the way they would an arbitrator. So that being said, across from where you put your index number, put jury trial, yes or no. Let's say for this made up case, we're going to put yes. Fantastic. Now we're going to go to our first heading, which is going to just say complaint. And right under it, we're going to put our preliminary statement. Your preliminary statement is you introducing yourself, you introducing how you know the defendant, and introducing the defendant. Each thought you have, each statement is one sentence, and you need to condense it to one sentence because each sentence is numbered. This didn't make sense to me at first, but I later learned that the reason for this is eventually the defendants are going to have to submit to the court something called an answer. And what the answer is them going line by line and saying true or false or not enough information. So for instance, they would have to acknowledge line one. So in this case, line one will be plaintiff Tara Rule is a however old woman from Southern California. The defendants, when it gets to the time they answer, they will say line one, true. Line one, who are you? Who is the plaintiff? What's your name? What's your age? Where are you from? You can put your profession if you feel it's relevant. Your next line, you're gonna say how you know the defendant. So in this hypothetical situation, let's say I went to go see Lady Ladyson to schedule a surgery to have a hysterectomy because my endometriosis, which I don't have in real life, just for the sake of this, the endometriosis treatments didn't work and it's out of control and I'm having so many complications. I just want the plumbing ripped out. And she denied me the right to that service because, you know, I could want kids one day and change my mind, even though I told her I didn't want kids. So now I'm suing her for age discrimination. So the second line, how do you know the defendant? So in my case, I would say plaintiff Tara Rule sought care from defendant Lady Ladyson at Hollywood OBGYN for treatment for her endometriosis on whatever date it happened. So October 1st, 2023. Your next line, you're gonna talk about the defendant or defendants. So I would recommend doing one defendant at a time. So line 3, Lady Ladyson, MD, is a provider specializing in obstetrics located in Southern California. Next line would be the other defendant, which is the corporations. Defendant Hollywood OBGYN is an obstetrics clinic in Southern California. Forewarning, this entire complaint is going to seem really, really repetitive because it is. We'll get into the reason for that in a couple of minutes, but for now, let's just move on to our second bullet point, our second heading, which is going to be the parties. Now, it's important to note that each heading you want to use Roman numerals, so this would be Roman numeral 2. The parties. And yes, I know we just introduced the parties, but this is where we go into a little bit more detail. Specifically with regard to your defendants. If you are suing a corporation as one of your defendants, you're going to need to know what kind of corporation you're dealing with. For instance, are they a nonprofit? Are they a place of public accommodation? Are they a retail store? Are they an LLC? And the way you can find this out is by just Googling the name of the company or corporation and then corporate information. It'll tell you what kind of corporation they are, basically what they put on their taxes. And this is going to be really important for your case. It's always best to err on the side of caution when it comes to providing the court with information, because you never want to seem like you're providing the court misinformation, false information, or at worst committing an act of perjury. You don't really know what could happen between the time of the event and filing. And because of that, it's always best, like I said, to err on the side of caution. Let's say that, as far as I know, last time I looked, Lady Ladyson was still employed at Hollywood OBGYN. But coincidentally, the day I filed my complaint, she quit or was fired. Because of that, I want to word it in a way that's basically saying, based on what I know, it may not be true, but based on the information I have, she's employed there. So a way you can word that, based upon information and belief. Dr. Lady Ladyson, MD, is a doctor who specializes in obstetrics and is currently employed at Hollywood OBGYN in the Southern District of California. This is where you're going to go into what kind of corporation is the company, if you're adding a company. Hollywood OBGYN is a 501c3 not-for-profit medical facility and a place of public accommodation located in the Southern District of California in Los Angeles County, Los Angeles, California. A moment ago when I said you need to have certain information like what kind of corporation and stuff they are because it's going to be relevant later and we'll talk about it in a few minutes. The few minutes has come. Now we move on to our third heading, which is jurisdiction and venue. So jurisdiction just relates to the area in which the law is upheld. So you're basically letting the court know that, yeah, this happened in the county that you reside in. You're in Los Angeles County and the event happened in Los Angeles County, so this is the proper court for it. Venue, on the other hand, is letting the court know that this is the appropriate type of court for this. So if your neighbor hits your car or something, does $5,000 worth of damage, and you're trying to collect on that, that would be civil court. That's small claims court. If you're going through family court, divorce, something like that, that's state court. For federal statutes, federal claims, district court is who handles that. So you're just letting the court, but mostly the defense attorneys know that yes, this is the proper court location. They oversee this presiding area that the event happened in, and they are the right court and the right type of judge to uphold the law in this type of case when it comes to these kind of federal statutes. So your third heading, jurisdiction and venue. Your first number under that is going to be something like, this court has jurisdiction over Lady Ladyson, MD, and Hollywood OBGYN, as each entity is within the Southern District of California and the events occurred within the Southern District of California in Los Angeles County. I know you might be thinking, okay, doesn't the court already know that? Of course they do. But the reason you have to do this, which kind of sucks, is oftentimes the defense attorneys, especially if they have a weak defense, they're going to try to get your case thrown out simply for things like following improper protocol, not doing something correctly, overlooking something, missing something. Because of that, you want to really make sure that they have nothing to work with. So not only are you letting the judge know that you know what you're talking about, you're letting the defense attorneys know that you know what you're talking about. Now you're going to cite your first kind of causes of action. So your causes of action, again, like we talked about in the previous video, these are the statutes and laws that you feel have been violated. As long as you have one federal statute that's been violated, you can also add in state claims, also known as tort laws, also known as common law, to add into your case as supplemental jurisdiction. We'll talk more about that in a second. But you're gonna kind of wanna go line by line with which cause of action, which federal law you feel has been violated. So in my fake case here, let's start with This court has subject matter jurisdiction pursuant to, let's say, the Affordable Care Act, Section 1557, as plaintiff asserts federal claims under the Affordable Care Act, Section 1557, 42 U.S.C., blah, 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 blah. Okay? So you're just basically saying plaintiff states that they violated this federal law. So this is where you can add in your supplemental jurisdiction, your state laws, your tort laws, your common laws, as long as they pertain to your federal claim. Let's say Lady Ladyson, when she denied me this treatment for my endometriosis, and let's say I had complications as a result, I had internal bleeding as a result, I can then go after her for malpractice. Malpractice is state law, but because it pertains to a federal statute, we can add it in as supplemental jurisdiction. Maybe I feel she acted negligently with that decision by prioritizing her beliefs over my right to informed consent. So I can add in negligence per se. Sometimes federal statutes don't have a type of relief, which is like financial compensation, because usually it's like kind of the federal government will just punish them for violations. However, that's one of the reasons you can use supplemental jurisdiction, especially as a pro se litigant, to be able to be compensated and get some justice for the wrong that has been done to you. A lot of state laws, most state laws, tort laws, and common laws do have compensatory damages as relief, sometimes punitive damages. We'll go into all those different types of damages in a few minutes. It's really important to add those in if you feel any of them are applicable. So a way you would word that is this court has supplemental jurisdiction over, let's say, 28 U.S.C. 1367A over state claims for malpractice. Now these like statute numbers and stuff are not necessarily the statute numbers. You're gonna have to, unfortunately, do your own research on those and find which ones pertain to, especially whichever state you're in. But again, this is a hypothetical case. Now we're moving on to your next heading, which is gonna be your table of contents. This is where you're going to list out the different statutes and tort laws, state laws, supplemental jurisdiction laws that you are going to be discussing in your complaint. And it's an index. So it'll say something like the Affordable Care Act and then page 9/20. Your next heading is going to be legal cases. So this is where you're going to add in relevant legal cases. So it's important to find other cases where someone has sued a defendant for something similar. So you can find these cases by simply Googling, let's say, OBGYN refused treatment because of childbearing age discrimination. You can use ChatGPT for something like this. However, it's important to vet the answers they give you. Sometimes AI can have hallucinations and they'll just make up fake cases, and you never want to submit any fake cases. Unfortunately, as a pro se litigant, we're at a disadvantage because we don't have access to the LexisNexis system, which is essentially like a very quick search engine where the attorneys can just type in discrimination cases, blah, 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 and everything will pop up. So unfortunately for us, we're gonna have to do a bit more research. You always wanna cite relevant legal cases, and you wanna make sure that the case is ruled in favor of the plaintiff. There are instances, like in my case, where no one has filed for a specific violation under a specific statute. For instance, in my case, I'm filing for a violation and for discrimination under Section 1557 of the Affordable Care Act. In the event that you are filing for a precedential case, we're gonna go into how you can present that case without having to cite relevant case law in a few minutes. Now we're gonna jump into our next heading, which is your factual allegations. This is where you tell your story. Again, you wanna condense each line, each thought to one sentence. It's really important you go in chronological order here and include things like dates and times. This is also where you can reference exhibits that you may be adding as evidence to your complaint. This is also a section where you can add things like footnotes, because remember, the judge is a judge. They're not a doctor, they're not a mechanic, they're not whoever you might be going after. They're not necessarily a specialist in any of those areas. So if there's something you feel the judge may not be very educated on, like certain medical conditions or things of that nature, you want to include footnotes and an explanation of these things. One of the most important things about the section of factual allegations is you never want to add intention to the defendant's actions. For instance, if you took some administrative action against the defendant prior to filing, and again, if you're confused by what that means, please see my previous video, and the administrative action you took was contacting the defendant's employer to try to get this resolved and you never heard anything back, you don't want to say that the company ignored you, because that's an intentional act. You want to say something like, plaintiff asserts that she filed a complaint within 30 days of the event happening to Lady Ladyson's employer, Hollywood OBGYN, and did not get a response from Hollywood OBGYN. So your first line can be something like, plaintiff suffers from a debilitating condition known as endometriosis, where the endometrial tissue found in the uterus grows outside of the uterus onto different organs and inside the pelvic and abdominal cavity, causing a number of complications, including internal bleeding, cramping, pain, irregular periods, etc. This is a great place to add your footnotes. You can put a little tick there. It'll bring you down to the bottom of the page where you can go into more detail about endometriosis, and you want to include in there the link to where you got that information from, or if it's from a book, cite that book. So in my hypothetical case, I said what I had. Now my next line, plaintiff sought care from Lady Ladyson, MD, for her endometriosis after failing all treatments and wanted to discuss surgery options to help manage her symptoms. Your next line, plaintiff sought care from Dr. Lady Ladyson, MD on October 1st, 2023 at Hollywood OBGYN at 11 a.m. Now, if you have, let's say, even your discharge paperwork from that day, this would be a great place to add an exhibit. So you can put in parentheses, let's say Exhibit A. And then you can make a copy of your discharge paperwork, print it out, and attach it to the end of your complaint and label it Exhibit A. If you don't have exact timestamps or don't remember exactly what time your appointment was, this is a good way to kind of word it so you're saving yourself from making it seem like you're trying to mislead the court. You can say something like, on or about October 1st, 2023 at 11 a.m., plaintiff discussed in detail her symptoms and previously failed treatments for her endometriosis. Your next line can be something like, plaintiff discussed with Lady Ladyson, MD, that she is not going to be having children. Maybe your next line is, Lady Ladyson, MD, informed the plaintiff that she would be unwilling to provide the plaintiff any additional treatments as she, quote, may change her mind about having children later on, thus violating her right to informed consent. After you kind of went through the events of the situation you went through, then you can kind of go into a bit more detail about how this has affected you. So for instance, you could say plaintiff continues to suffer from complications resulting from her untreated endometriosis. Maybe you've lost your job because you called out sick too many days. So you want to kind of go into more of the damages territory, right? Plaintiff lost her job due to too many sick days calling out due to the pain of her untreated endometriosis. Plaintiff now has to seek psychotherapy due to the trauma of being denied treatment. You want to just kind of paint a picture of how you've been harmed. Now we're going to move on to our first cause of action. Again, our first federal statute that we feel has been violated. I'll go into a little bit of detail here on how to write this up and explain why you feel that your rights have been violated. However, I will make another video that will go into way more detail regarding causes of action, how to find different causes of action that are relevant to your case, and how to properly express these causes of action to the court. So again, another heading, first cause of action. Right under that, you're gonna put in parentheses the statute number and then the name of the statute. So for instance, 42 USC, the Affordable Care Act. Now you wanna put this next line, with all of your causes of action. You're gonna say something like, plaintiff reinstates, incorporates by reference the preceding paragraphs above as if fully sets forth herein. All that means is you're referencing everything you just said. You're referencing all your factual allegations, like, hey, everything I just said pertains to this federal statute. Under that, you can go into more specifics if you feel that there are certain lines in your factual allegations that really prove your case. So your next line could be something like, the allegations contained in paragraphs 2 through 4 constitute discriminatory policies and practices that are unlawful pursuant to the Affordable Care Act, Section 1557. This whole thing is going to feel real repetitive because it is. Your next line, the discriminatory policies and practices of Lady Ladyson MD and Hollywood OBGYN violate Section 1557 of the Affordable Care Act. You're going to reinstate your jurisdiction and venue here. So your next line is going to be, Lady Ladyson MD and Hollywood OBGYN are located in Los Angeles County in the Southern District of California. The Southern District of California has jurisdiction over both Lady Ladyson MD and Hollywood OBGYN. Your next line, you're going to point out that to the best of your ability as a pro se litigant, you have exhausted your administrative remedies. Again, if you don't know what that means, please see my previous video, but for the sake of this video, I'll assume that you watched the first video. So you want to say something like, plaintiff exhausted all proper administrative remedies. You can reference the paragraphs if you'd like. And this court has jurisdiction over violations of the Affordable Care Act pursuant to Section 1557. Your next line, very repetitive. Lady Ladyson MD and Hollywood OBGYN are in violation of the Affordable Care Act, Section 1557. Now, instead of creating a whole new numbered line, you're going to indent and you're going to kind of do like A, B, C, D. You know what I mean? You're going to hit your bullet points. Start with the statute itself and what it says and which parts of the statute you feel are relevant. So, for instance, in this hypothetical case, we put point A. ACA makes it unlawful for any healthcare provider that receives funding from the federal government to A, refuse to see an individual or otherwise discriminate against the individual based on race, color, national origin, sex, age, or disability. Something I like to do is kind of bold the parts of the line that are relevant to my particular case. So I would bold refuse to treat an individual or otherwise discriminate based on age, sex. In your next line, you're gonna kind of want to touch on anything that you haven't yet touched on relevant to the federal statute. You notice the line I referenced in the Affordable Care Act where it says any facility receiving government funding. Well, we haven't discussed that with the court yet. So this is a great opportunity right here and now to state why the provider and why the facility is liable in this situation under the statute, because yes, they do receive federal funding, right? So let's say they take Medicare and Medicaid for the sake of this hypothetical situation. I could say something like Lady Ladyson MD and Hollywood OBGYN are insured by federal Medicare and Medicaid. As such, they receive government funding and must abide by the policies outlined in the Affordable Care Act. Like I said, there's a lot more we need to go into regarding your causes of action, but for the sake of this video, we're just gonna hit the basics. And in another video, I'm gonna go over kind of like the extra things you can add to your amended complaint to really kind of like nail down your points. So now, still under your first cause of action, remember earlier we talked about relevant case law. So other cases where someone filed a lawsuit for a similar issue and the court ruled in favor of the plaintiff. Here's where you're gonna wanna cite those. And each case law is gonna be a different line. You can say something like supporting case law, one, blah, 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 blah case. And then right under it, you're gonna kind of give a short brief of what the case was about and that they ruled in favor of the plaintiff. Now, in precedential cases like mine, where no one has filed a claim for a certain statute yet, you, instead of using relevant case laws, you're gonna want to explain why it's important that this is heard in court. You wanna mention things like you're a pro se litigant and you are entitled to the right to a fair trial. You can bring up things like clear statutory language, meaning the statute that's written is not ambiguous. It says right there you can't discriminate based on age and sex. Therefore, there's no need to provide relevant case law because it says it right there. In another line, you can talk about why it's important that the provider or place in this case is held accountable, because it meshes with the intent of the law, which was originally written in this case to, avoid discrimination. Additionally, if the court does see and hear this case and it rules in your favor, this will set an example for providers to really steer clear of discriminating against patients in the same way. So you want to kind of explain why it's important if you don't have case laws to back up your position or the point you're trying to make. Now, let's say your second cause of action is going to be your supplemental jurisdiction or your state law, your tort law, your common law. Let's, in this case, use negligence. Second cause of action, right under it, negligence. You're going to follow a very similar formula. So right under that, plaintiff reinstates and incorporates by reference the preceding paragraphs above as if fully set forth herein. Your next line. Declaring that, meaning you, the plaintiff, are declaring that defendants Lady Ladyson and Hollywood OBGYN acted with negligence. Your next line. The Southern District of California has jurisdiction over this claim as it involves medical negligence that occurred within the district. Your next line. The Southern District of California has jurisdiction over this claim as the negligent actions occurred during violations of federal statutes and laws. Now, your next line is going to be Dr. Lady Ladyson, MD, acted with negligence. A defendant who violates a statute or regulation without an excuse is considered to have blah, 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 breached their duty, right? So you're going to want to say, hey, Lady Ladyson did act with negligence, and here's how. Again, I'm going to make a whole other video on how to use these federal statutes or case laws, tort laws, things of that nature to prove your case, because there is a certain formula you have to use, because each statute, each law, each state law basically gives you an outline of, in order to prove, let's say, negligence, the plaintiff must outline the ways in which the provider did X, Y, Z, and it'll give you a step-by-step guide, but each law is different. For the sake of this video, to keep it as short as possible, we're not going to go into that. Again, that's going to be another video. The next lines you're going to add in are going to be essentially using whatever guidelines the certain law or statute is giving you as the plaintiff, where you have to prove X, Y, Z. And you're going to use the text that's within the statute. And then you're going to, under that, kind of indent. So point A would be Lady Ladyson did X, Y, Z. And you're going to be referencing, hey, you have to prove this. Well, Lady Ladyson did this, which does prove that she's in violation. And I know this is confusing. So in addition to the kind of fill in the blank Google Doc, I'm going to include a fake lawsuit document where you can kind of follow along and see what I'm talking about with these kind of more complex areas. That we'll go into more detail later, so you don't get too overwhelmed, so you can kind of see, oh, okay, I see what you're talking about, because it's confusing, and it's intentionally confusing. Now we get to the fun part. It's called the prayer for relief. So you're gonna have a new heading, and your prayer for relief is what you're asking for. So different laws and statutes have different forms of relief. You can be entitled to compensatory damages, which is essentially compensating you, bringing you back to the position you were in prior to the event happening. And that doesn't necessarily mean just financially, emotionally, physically. And compensatory damages generally are not considered taxable income because, again, they're just kind of paying you back for what you went through. So if you're on government assistance programs, Social Security disability, things of that nature, it shouldn't be impacted by compensatory damages and compensatory relief. Punitive damages are a punishment. So where the court says, hey, you messed up so bad, we want to set an example for other providers to not do the same thing. This is your punishment. There's damages where essentially the court can come in and say, hey, you need to retrain your employees. Underneath your prayer for relief heading, you always want to start with wherefore. Wherefore, plaintiff respectfully requests judgment against defendant Lady Ladyson as follows. And then you're going to go A, B, C, D, blah, blah, blah. So for instance, A, train all defendants' current and future employees and agents with responsibilities related to design, implementation, and operation of defendants' patients' rights laws, blah, 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 blah. You see what I'm saying? Granting the plaintiff such and other further relief as may be just and proper. And you're going to do it for each defendant. So one of them's for Lady Ladyson, your next wherefore. Hollywood OBGYN. And then you are done with your complaint. You're gonna add your exhibits if you have any. The last thing you wanna do at the bottom of the page is you're just going to sign it and date it and type out your name. And then your complaint is done. You wanna make sure you've done everything correctly, and once you have, that's when you can go back and number each of your lines and number your pages, and then you can fill out your table of contents. In the next video, we're going to talk more about how to properly express your causes of action, how to read these laws to see what steps you need to take and what things you need to say to prove your case in your causes of action in your complaint. We're going to talk about evidence and how to include your evidence. We're also going to talk about your initial filing and forms you're going to have to bring with you for your initial filing, as well as how to serve the defendant. So I hope you found this video helpful. If you did, please like,
please subscribe,
please turn on that notification bell so you know when the next videos come out. Please consider becoming a patron on my Patreon, which again is linked down below, so I can continue to make these educational videos for you guys. I will see you next time on How To with Tarot Rule. Bye!